You or your spouse must fulfill the residency requirements for California. This means that at least one of you must have been a resident of California for the 6 months prior to filing, and a resident of the county in which you file for at least 3 months. If this requirement is met, next you will begin the divorce process by filling out Form FL-100. This is your petition to fully file for divorce. If you don't meet this requirement, you can file for a legal separation and then file an amended petition requesting a divorce once you've met the requirement. For domestic partnerships, it's different. There is no residency requirement for dissolution of a California domestic partnership. Form FL-100 can also be used for the dissolution of a domestic partnership. You will need to fill out the top box with all the necessary information pertaining to you and your spouse or domestic partner. Even if you are married and domestic partnered, you may use this one form. In the top left box, type your name, address, telephone number, and email address. Next to Attorney for, leave blank or type in self-represented. Type in the name of the county in which you are filing. If you do not know what the address of the court is, you can go to the link on your screen to find out. Next, you are the petitioner since you are filing the petition. Type your legal name, and next to respondent, type your spouse's legal name. Leave the case number blank for this form. Your court clerk will assign you a case number. Under Petition for, check either the box for dissolution, divorce, or legal separation. If you are dissolving a marriage, check that box. If you are also dissolving a registered domestic partnership, check that box. Item 3, Statistical Facts, refers primarily to the date of separation, a critical issue that can significantly affect your case. Property acquired by either spouse after the date of separation is considered separate property in the state of California. While helpful to establishing the date of separation, you don't actually have to move out of the family home in order to establish the date of separation. Family Code Section 70 states, A. Date of separation means the date that a complete and final break in the marital relationship has occurred, as evidenced by both of the following. Number 1, the spouse has expressed to the other his or her intent to end the marriage. And 2, the conduct of the spouse is consistent with his or her intent to end the marriage. In determining the date of separation, the court shall take into consideration all relevant evidence. Item 4 requires disclosure of the existence of any minor children that were born before or during the marriage or domestic partnership. Additionally, a declaration under the UCCJEA must be attached whether there is any dispute over custody issues or not. Item 5 refers to the legal grounds for your divorce. Usually, in cases where the parties agree and they are pro se, it is item 5A, irreconcilable differences, that is checked. Item 6 refers to the type of custody and visitation you want to have with your children. You will want to address legal and physical custody. If you have put a lot of thought into co-parenting, you may want to attach some or all of the forms listed in this paragraph. It's not required, but it can be helpful. Legal custody means the right to make major decisions about your kids' welfare, health, and education, while physical custody refers to where your child will live after your divorce or separation. Items 7 and 8 refer to child and spousal support. If you are going to be asking the court for child support, you don't need to check any box. However, if you have special circumstances, such as an adult disabled child who requires support, you should check the other box and explain what additional child support orders you need. Pay close attention to paragraph 8 regarding spousal support. Check the boxes that relate to your position. For example, If you are the petitioner and are requesting support, you will check box 8A. If you don't want to ever pay spousal support, check the box that terminates the court's ability to award spousal support. The term reserve refers to no request for spousal support at this time, but you or your spouse may want the ability to request it at a later time. Items 9 through 10 refer to property. Separate property is property acquired before the date of marriage or after the date of separation, or during the marriage by gift or devise. If there are no separate property assets or debts, check box A. Assuming there is separate property, such as a portion of a retirement account that you contributed to before marriage, you will check the box next to 9D. You can either check the box next to property declaration and then specify all of your separate property or debt in that form, or you can write a more general statement such as all property acquired before marriage or after the date of separation, plus the rents, issues, and profits thereon. You want this separate property to be confirmed to you. If you don't think that your spouse is going to formally respond to your petition by filing his or her own response, then you will probably end up proceeding in the divorce by what's known as a true default. In that case, the court will compare your eventual judgment of divorce with the petition you are preparing now. If you are requesting that assets and debts be divided or assigned to either of you, that you have not disclosed in the petition or its attachments, then you may run into some trouble getting the judge to sign off on your judgment. As such, if you believe you may be proceeding by true default, make sure to be as specific as possible and avoid the general language I quoted earlier. Community property is essentially any property earned as of the date of marriage up through the date of separation. Some property or debt may be partially community and partly separate property. You do not need to know the exact amounts of the community property versus separate property interests at this point, but you should acknowledge them. So, for example, if you have a retirement account that you contributed to before the marriage and then later made contributions while married, it will be part community property and part separate property. Your earnings or losses on the portion that existed before marriage will also need to be factored in. As such, it can become a complex analysis. You can use approximate amounts of community property versus separate property interests, or you can list the account in both the community property and separate property sections or attachments to the petition. Item 11 can include requests such as a change of name and perhaps an initial request for an expert witness, such as an accountant or business evaluator, to be appointed. Don't forget to print and sign your name at the bottom of page 3. Now that you have completed the petition, which is the FL 100, you will need to prepare the FL 110, summons, and FL 105, declaration under the UCC JEA if you have children. Let's start with FL 110, the summons. Next to Notice to Respondent, write your spouse's name. Next to Petitioner's name, write your name. Scroll down to the bottom of the page and write the name and address of the court in which you are filing your petition. Finally, fill in your name and address. There is nothing for you to do on page 2. You have now completed the FL 110. If you have a child or children, you will also need to complete the FL 105, declaration under the UCC JEA, and file it with your petition and summons. If you have any difficulty completing this form, check out our instructional template and/or ask a Hello Divorce attorney to walk you through it. Once everything has been filled out, double-check, you can file and serve these documents. You will need to pay a filing fee when you file your petition. While costs may vary, You should expect to pay the clerk of the court approximately $435. Bring your original and 2 copies of each form you intend to file. The originals will go to the court, and 1 copy will be for your records, while the other copy will be served on your spouse. Finally, after you have filed your petition, summons, and UCC-JEA, if applicable, you will need to serve your spouse and then complete and file an FL-115, which is a proof of service of the petition. The FL-115 should also be filed with the court, but does not have to be done immediately. On the top of FL-115, fill in your contact information, court and case information as you did on the petition. Check box 1A and then skip down to 1D to see if any other boxes apply. If you have children, check 1D1. Complete paragraph 2 by stating the address where your spouse was served. Now remember, service must be done by a person over the age of 18 and cannot be you. You can have a friend, a private process server, colleague, or sheriff serve papers related to your case. If you were able to have the respondent personally served, check the box 3A for personal service. The person that served your papers for you must write in the date and time they served the papers. If your spouse agrees to accept the papers, a third party may mail them to your spouse with a notice and acknowledgement of receipt, Form FL-117, which must be signed and returned to the court for filing, along with the proof of service. Check box 3C, fill in the date and city, and then check 1. If your spouse is living outside of California, the forms may be mailed by registered or certified mail, with return receipt requested. The receipt must be submitted to the court with the proof of service. The person who served the papers must write their name, address, and phone number in paragraph 4. Don't check box 4A unless your spouse is a minor, ward of the court, or conserved. If your server is not a registered process server, check box 4B. If you hire a process server, they will likely complete this form for you on your behalf and may even file it for you. Or at the very least, they will complete this portion of the form for you. If they don't, you will need to complete 4C. Paragraph 5 must be checked unless a sheriff is serving the documents for you. Finally, the person who served the documents should print and sign their name and date their signature. Don't forget to file FL-115, your proof of service, and then FL-117 if your spouse signed a notice and acknowledgement of receipt. You have completed the first step toward obtaining a dissolution of marriage and/or domestic partnership. While you wait to see whether or not your spouse files a response to the petition, you can begin working on your mandatory financial disclosures.